Hello and welcome to this episode of Old Square Tax Chamber's TaxSnax on judicial review against HMRC. I'm Harriet Brown and this is Ross Birkbeck. We are both barristers at Old Square Tax Chambers.
Hello, everyone.
So this episode forms part of our series on tax litigation, effectively. And one of the oddities of tax litigation arises in relation to judicial review, or I think it's a bit of an oddity, I think, anyway.
I think so.
So first of all, I think it's probably helpful if we set out what judicial review actually is, and I'm going to let you start on that one, Ross.
Okay, thanks, Sarah. Well, basically, obviously, judicial review is the process by which you can challenge a public authority that has made a decision that prejudices you. So if the government or any wing of the government or in fact, every sort of quasi-public body or body acting in a public capacity makes a decision that affects you, and you think that is unlawful in the sense that the public law prescribes, then you can challenge that by way of judicial review. So it's a procedure for essentially taking the government to court in simple terms.
Yes, and of course you can take the government to court in the same way that you can take anybody else to court. But this is, as you say, it relates to where the government has made a decision usually, and you say that decision in some way treats you unfairly, infringes your rights, or something like that. And it's quite a modern remedy, isn't it? I think it only first sort of started being developed in the 1950s or possibly even 1960s.
Certainly in its modern form. Yeah, and of course it's to challenge the exercise of sort of public functions and
yes.
such and public authorities, statutory authorities as well.
So the reason it comes up in tax a lot, and it does come up in tax quite a lot, is that HMRC often do things which aren't just an exercise of a clearly defined statutory duty. So HMRC have discretions. They have a general power of management discretion. So that means that they can sort of, I think what comes up in judicial review a lot is this idea that sometimes HMRC can choose not to collect tax which is properly due, and that might be a proper exercise of their powers of management. But they then have to exercise those sorts of discretionary powers. That's the big sort of overriding one, but you also get them in relation to individual sort of parts of the legislation. So another good example where it might come in, I'm not sure there's a case on it, but for example, in the Transfer of Assets Abroad Code, where HMRC have a discretion, which has to be reasonably exercised, but to decide how they're going to charge tax as between two taxpayers who are both technically liable for the same amount. That is another sort of area where judicial review might come in, because it's you're not saying HMRC have just got the law wrong, it's this public law context. So I think that's probably why I'd say it's relevant to tax. I don't know if you've got anything to add.
Yes, I mean, the way I sometimes think of it is, in the sense, judicial review is the backstop when dealing with the revenue. Well, one of the grounds of judicial review is a public authority body's done something unlawful, and if they've wrongly assessed you to tax, absent all the rules about disputing tax, you could probably use the judicial review procedures. But they're the sort of backstop, aren't they? The catch-all for revenue decisions in case that you want to challenge for being either unlawful or unreasonable.
Yes, and of course they are very much a last resort. It's a remedy of last resort because you have to have exhausted all your other remedies, and this is now causing a problem in tax since about 2013, starting with a case called Noor. And what happened in Noor was the upper tribunal, without the benefit of counsel for the taxpayer, they may not have seen that as a benefit, I personally think it might have benefited them, decided that, very broadly speaking, the first tier tribunal, because it's a statutory tribunal, has no power to hear public law points, in essence. So they can only deal with what's said in the statute. And even if theoretically, even if HMRC have made a really bad decision in terms of exercising a discretion, then the first tier tribunal can't deal with that. Now, another one of the little sort of wrinkles around judicial review is that you have a very short timescale in which to bring your proceedings. The limitation period is as soon as possible, or at the latest 3 months. And so the first thing to note there is, theoretically, within 3 months, you could possibly be held to have made your application out of time. It doesn't happen often, and I don't think I've ever seen it happen in tax. I think sometimes it does in things like immigration. But 3 months from effectively the point complained of is the time limit. And so this causes problems, because you can't just go to the first tier tribunal, get that all done, find out that you've been to the first tier tribunal and you've lost, and you can't appeal to the upper tribunal, say, or even if you appeal to the first tier tribunal, the upper tribunal, the Court of Appeal and the Supreme Court, you get to the end of all that, you might be able to bring a judicial review ground in at the upper tribunal, possibly, but maybe not. You've completely run out of time to bring your judicial review. So you end up with this unfortunate situation where you have to bring your tax tribunal proceedings and start your judicial review proceedings before the High Court at the same time.
And what you often see in that situation, don't you, is that for example, the Samarkand case, where taxpayer starts judicial review, they start an appeal in the first tier tribunal both at the same time, and then the judicial review proceedings get put on hold until you get to the upper tribunal, which can hear them both, and they get brought back together again, which is, think 2 years later. But you have to sort of pause everything whilst the first tier tribunal makes its initial findings on the actual tax liability.
Yes, when this way
together.
Yes, yes. So the important thing, I think, one of the important things you've highlighted there is that the upper tribunal does have a statutory power of judicial review. So you can, as you say, you can have it. What you do is you start it in the High Court and then you have it transferred across, which is not complex, but it's not ideal. And one of the things that I've never understood about it is, so you've got this first tier tribunal decision in Noor, and I think we're going to talk about the decisions that have come after that a bit in a minute. But you've got that decision, and that to me seems completely inconsistent with the idea that judicial review is something that you need to do quickly. There shouldn't be a lot of delay in it, because of course you're baking in the delay. But also, you get this tension between you needing to bring an application quickly, but also having to have exhausted all your other remedies. So it seems to me that technically you could seek to oppose or strike out a judicial review application, or an application for permission for judicial review, on the basis that, well, HMRC could seek to, on the basis that, in fact, you haven't exhausted all your other remedies, because you've still got first tier tax tribunal proceedings. Now, in practice, that doesn't happen, but I think it does highlight the issue with this dual process, because, as you say, first of all, you get the delay, then you get this point that actually, if you're still going through the first tier tribunal, you don't know whether you haven't exhausted.
And I think particularly it's a problem because where you've got a difficult question as to what exactly the jurisdiction of the first tier tribunal is, because being able to make that distinction as to what bit of the claim do we throw down the judicial review route, what bit of our defence do we throw down in there, and what do we throw at the first tier tribunal, requires you sometimes to identify right off the bat where the edge of the first tier's jurisdiction lies. And sometimes that's it's still something the courts are debating in certain cases, exactly when public law considerations can be come into a tax decision. And so if you get that wrong, you're going to be out of time for your JR.
Yeah, and I think Noor, the initial case that I mentioned, that sort of was almost quite a bright line, but subsequent cases in the last 10 or 11 years, they've actually been giving us a bit, there's a bit more wiggle room, isn't there? Wiggle room, that's the
yes, it seems to be bringing in the principle that if the assessment of tax involves a discretion that the legislation requires to be reasonable, the tax legislation, then it's within the first tier's jurisdiction.
I think that's where we're developing to. I'm not completely convinced that we've absolutely got there yet. But I think we are getting there, and so we've got a number of cases that sort of are starting to drive us in that direction. So we've got Beadle,
Yes.
which tells us that persons may defend themselves by challenging the validity of the enforcement decision or some antecedent decision on public law grounds, save where the scope for challenging alleged unlawful conduct has been circumscribed by the relevant statutory scheme, which excludes such a challenge. So that's a much narrower point of view than I think Noor was. And so Beadle Beadle says, well, look, you've got to look at what the statutory regime says. And if that if sort of the words of that stop you using or stop you referencing public law, then you can't. And we've then got
But it's a sort of implied stopping of public law, isn't it? Because, you know, in that case, there was no express provision saying
yeah,
it's implied, which makes it difficult.
Yeah, on a proper you have to look at it and say, on a proper construction, am I prevented from challenging an exercise of discretion here? And as you say, it's not like provisions say, oh, and by the way, there's no judicial review here, or there's no public law basis for challenging this.
Yeah.
So then we've got, is it Zeman or Zaman? Zeman, which was about Section 73 of the Value Added Tax Act. And what that case said effectively was that in the circumstances of that section, the taxpayer should be entitled to defend himself by challenging the validity of the enforcement decision or some antecedent decision on public law grounds, unless the entitlement is excluded by the relevant statutory regime. And that provision, and I think this is a little bit helpful because it gives you some ideas of where that ambit might be. Why they said there was scope for public law challenge there was because the expression was that the commissioners may assess the amount of VAT. So may as opposed to must, they have a discretion rather than a duty.
Yeah, but it seems to me it'd be fairly easy to read that. Well, that gives them an unlimited discretion, which, you know, if they exercise it, that creates a tax liability, and to go behind that, you'd have to go to judicial review. So it's a very grey line, isn't it?
I think it is, and that of course brings in that sort of that perfect line of cases, which is also, I think that's excise duty, isn't it? Perfect. But what causes the liability? And I think that is going to be different where there's a must mandatory type language and a may discretionary type language. Because I think what perfect says is where you have the must type language, it is the liability arises absent the assessment. I think as you've sort of alluded to there, where you have the may language, it maybe has to be the assessment that causes that to arise. So that's sort of a line that one perhaps could draw. Another interesting case on this was Lobler, which is interesting for a lot of reasons. This was an upper tribunal case, which is primarily interesting for a very broad interpretation of equitable principles and their application. But in there, it was said that it would be surprising if Section 50 sub 6 of TMA left it to the first tier tribunal to decide whether or not a particular charge to tax were reasonable. And I think that's making the same sort of point that you're making, which is there's an awful lot of provisions which are going to allow judicial review grounds in if you take that Zaman sort of approach. I think that was the point you were making.
Yes, exactly. Yeah, it's not always easy to tell whether there's a discretion built into the assessment. And how a particular statutory provision may be intending, what exact powers it's trying to give the revenue in terms of discretion and in terms of making a reasonable decision. Because, you know, often with the statute, it's the revenue have the power to assess if, on a reasonable view, something is the case, and of course that brings in, you know, sort of questions of reasonableness into the actual tax assessment. That's clearly within the scope of the tribunal to decide whether something's reasonable in that sense. But where you've got a wider discretion that doesn't have an express test, when can you challenge it for being unreasonable in the public sense?
Yeah, and so that sort of brings us quite nicely around to on what grounds can you challenge a decision of
Very
HMRC.
elegant.
So we have traditionally illegality, irrationality, and procedural impropriety, though such categories have been described as non-exhaustive and not mutually exclusive. And then one that's become increasingly important in tax, I think certainly over the course of my career, has been I'm going to say conspicuous unfairness. Some of the judgments don't like conspicuous unfairness as a phrase, but there aren't any sort of very much better phrases. Nobody likes all of them, essentially just being desperately, desperately badly unfair, I think.
It's sort of, I mean, because technically the concept of irrationality captures unfairness and expectation and all of that,
Yes.
doesn't it? And the courts occasionally remind us of that. But yes, in reality, you break it down to, have I been treated unfairly? You know, and it has to be very, very, as you say, conspicuous.
Yeah, I think for me, maybe the unfairness ground essentially results is sort of, it's the part of irrationality that says, have I been treated differently to the people around me, as opposed to have I just been treated irrationally in a vacuum? So does the irrationality arise out of a different place, out of a difference in treatment to people in substantively the same position, as opposed to just sort of like standalone irrationality, if you like?
Exactly. And why it often so often crosses over with legitimate expectation, which is the idea that whether by practice or by express statement, that the revenue have led you to believe that you will be taxed in one way, and then they turn around and tax you in another. That's often the heading used in tax cases, but it's a brand of unfairness, which I say is in itself a brand of irrationality.
Yes, yes. So that, yeah, it's messy and ill-defined, isn't it? But essentially, if there's been something illegal, something irrational, or something that is procedurally improper.
So yeah, so I mean the other, you know, is because procedural impropriety is a claim that often is you know, a chimera in the sense that even if you win, all you do is go back to the beginning and get the decision made again. You
Yeah.
can claim the revenue have acted procedurally improperly, and the result will be, well, now they have to act procedurally properly, and they get to remedy their decision and remake it.
Yes. So that, yeah, as you say,
The same outcome. So you can end up fighting a torturous and long-winded claim that gets you nowhere.
yes, and I think you don't see procedural impropriety in that sense very often in tax cases.
No. So I have had one success with it, I think, in the context of APNs,
Okay.
where essentially the revenue were unable, their evidence was very poor, and the judge was very clear during the hearing that they had not shown how they had made the decision, and if they were unable to show how they had made it, they were unable to show that it was fair. And actually we didn't even get a judgment. The revenue pulled the APNs before it was handed down.
It's still a result.
But
Still
it's still yeah. And again, you know, actually process sometimes can be important.
Yes, and I suppose you could, procedural impropriety might get you somewhere if the time limit for, say, a revenue official to remake a decision, if that time limit had passed, because then arguably they would be out of time, for example. Again, I'm not sure I've seen that in the cases. I've certainly not seen it in practice, but I guess that could be a possibility.
Yeah.
And the
other
other
thing to watch out for, of course, is it section 31, the provision that says that even if a court finds essentially the grounds of a judicial review claim being made out, if they also decide that had the mistake not been made, the outcome would have been fundamentally the same, the claim will be denied. So you can be sort of successful on all your legal grounds, and at the end the court goes, well, you're right, but it doesn't really make any difference.
so what? Yes, the so what outcome.
Yes, exactly. They were being unfair, but if they'd been fair, you would have still paid the tax, or you know, essentially.
Yes, and that's always an issue with tax, I think, is because you get this in terms of, I think, a lot of the time when people look at suing tax professionals, it's the same thing, isn't it? They say, well, you understand you're not going to get the tax back because you would always have paid that because that was the tax that was due. They told you it wasn't due, but it was due. The fact that they got it wrong doesn't change the instance of charge. So get your professional fees, maybe get some penalties and some interest, and it sort of stems from the same thing there, doesn't it? Which is that actually, fairly or unfairly, you're still paying the tax. So it's the other thing that judicial review tends to intersect with is human rights. Now, you can raise human rights sort of in a standalone way in the FTT without having to argue all of this. Well, this legislation sufficiently inclusive to allow me to argue public law grounds. But quite often you will argue for an illegality, irrationality on the grounds of some infringement of a human right. In tax, most commonly Article 1, Protocol 1, Article 6 in the case of penalties.
Yeah, or some procedural point.
Yes, some procedural unfairness point, or discrimination.
Or access to justice,
Yeah.
Yes.
So those, I think that's the other point to remember. The process is, we've sort of highlighted one way the process is slightly different, and another way the process is slightly different. You have a sort of a threshold application called an application for permission for judicial review when you go to the High Court. So you actually have to have a judge look at it first and say, yes, this isn't completely spurious. That can be a two-stage process, because if the judge says no on the papers, then you can go and have a hearing. But the point is, if you've got this dual application process going on, you are racking up costs even before you've started, unfortunately.
And my experience is the revenue will fight on permission very hard, even if there is substantially a good claim and really think that public authority shouldn't be fighting permission to dispute this point. They'll fight time limits, they'll fight, they'll claim you're early and late at the same time, alternative remedies, all of that stuff at the permission stage.
Yes, I was going to say, I've never seen a revenue opposition of an application for permission that didn't say, oh, and it is 3 months, but they should have applied earlier.
Yeah, exactly.
It's like, I'm not being deported. There's still a purpose to these proceedings. I'm not, it's not that they've been rendered pointless by the passage of time. But yeah, I've never seen that. But as you say, also at the same time saying, oh, well, yes, and you've still got another remedy.
Yes, exactly. Yeah, and they almost invariably say that in tax matters. They say this is for the tribunal, and until we assess you, you can't do anything, and that sort of thing.
Yes. And that's the other way that judicial review has been tried fairly unsuccessfully, it has to be said. There was that Bishop case, I think in the 90s, where they tried to judicially review a refusal to give advance clearance on a tax process. So it was non-statutory clearance, and that didn't get any traction. That did not go well. So yeah, that is a sort of a slightly a rapid meander through judicial review. I don't know if there's anything else that you feel we should desperately have said, Ross.
I'm shoving on my list. I don't think so. I think we've somehow covered most of it.
So yes, perhaps not as organised as we might ordinarily like, but it's always nice to just have a discussion. So yes, I hope that's given you a bit of insight into judicial review and tax, and do have a look at our other episodes on litigating with HMRC.
Thanks, Harriet.
Thank you.